Good afternoon. Thank you all for joining us. We're going to be talking today about how smart IP management drives innovation and unlocks government incentives. My name's Esther Carter. I'm one of the partners at Moore Kingston Smith. I'm sure many of you are familiar with who we are, but for those of you that are less familiar, Moore Kingston Smith is a leading audit, tax and advisory firm. We work with businesses across all different industries, as well as not-for-profit organisations and private clients. And we're also part of More Global, which is an international network with a presence in over 100 countries. So very well placed to help our clients with their increasing international endeavours. So, many companies create valuable intellectual property, but they don't safeguard it properly, or they fail to realise that government incentives exist to make those innovations much more affordable. So whether you're developing software or algorithms or designing new products or improving existing technology, aligning effective IP management with incentive claims, they can help really protect your value and maximise your returns. So we've got a panel today. They're going to try and help us sort of demystify IP strategies and walk us through all the different government incentives that are available to support that innovation. So they'll be explaining sort of how the core elements of effective IP management, how to protect and demonstrate the value of innovation, and how to align IP and R&D activities to unlock incentives such as R&D tax relief and the patent box. So I'm delighted to be joined by Adrian Bennett, who is a partner at Venner Shipley, which is a leading full-service European intellectual property firm. Adrian is a European and UK patent attorney with more than 25 years experience advising his clients on patent strategy and managing complex proceedings before the UK IPO and EPO. And he's a former aeronautical engineer with British Aerospace. We definitely don't get many of those on our Enterprise Series webinars. And so with that, he brings very much sort of a lot of deep expertise across aerospace, fluid mechanics and advanced engineering technologies, working between London and the Harwell Science and Innovation Campus. Also like to welcome David Byrne, who's the director of our R&D team here at Moore Kingston Smith. David specialises in R&D government incentives, combining technical expertise, project experience, as well as stakeholder engagement to help innovative businesses secure the funding that they are entitled to make sure they don't miss out. And with several decades of advisory experience and a background in software engineering, David has led some of the UK's largest R&D tax relief claims across multiple sectors, bringing a strong working relationship with HMRC over that time and delivering really robust claims for even the most complex of projects. So before we start today, a little bit of housekeeping. Please submit questions through the Q&A, much easier to manage them there. And please do ask questions. This webinar is for you. So more questions make it more interactive, and I'll try and weave those questions in through as we go. Today's session is being recorded, so it will be available on our website. So please do share with any peers or anyone else who is interested in today's topic but couldn't make it. And lastly, please do fill the feedback form out that we'll share with you at the end of this webinar. It's super helpful and helps us to shape future webinars. So to get into the meat of things, then I'm going to start with you, Adrian, if I may. So sort of in your experience, give us the sort of the top 3 reasons that IP strategy really becomes pivotal for companies' growth?
Yes, thanks, Esther. Hello, everyone. It's nice to be with you all today. So firstly, I would say IP strategy is fundamental to protecting and maintaining competitive advantage. That's probably its most commonly understood purpose. Most innovative businesses are built on some differentiating technology, process or brand, which provides an advantage in the market, but such advantages need protecting. Competitors move fast, markets evolve quickly without registered IP like patents, trademarks, designs, or even carefully managed trade secrets. It becomes very difficult to prevent others from copying or eroding your advantage as a company. So a good IP strategy identifies what should be protected, how and when, so a company isn't left exposed. Secondly, I would say IP strategy can materially strengthen investor confidence and company valuation. Investors often look for evidence that a company not only has innovative ideas, but actually controls them. During investor due diligence, questions often asked are like who owns the IP? Is it protected? And the answers to those types of questions can be a significant factor in investment decisions. And for a technology company, patents in particular can be a compelling signal. They show that a technology is genuinely novel and that the company is serious about protecting its market position. And IP registrations like patents and designs and trademarks also create tangible, transferable assets that enhance valuation for venture capital investors, but also for strategic partners, licensees, and potential buyers too. And then thirdly, a good IP strategy can really significantly reduce long-term commercial and legal risks. Many companies discover IP issues too late. Perhaps a competitor's patent blocks their product launch, or an earlier assignment of rights was never signed correctly, or a key employee walks away with important know-how. All of these problems can be quite difficult to solve once they arise, and are certainly more expensive to deal with reactively than proactively. So your IP strategy should help to ensure ownership is clear, freedom to operate risks are managed early, and should allow a business to scale without running into avoidable disputes. So I think overall, I would say a smart IP strategy will be protecting your edge, strengthening your credibility in the market, and avoiding future problems for you that could slow growth. Those would be probably my top three.
Thanks, Adrian. And I mean, if so you're a growth company, how do you map what's protectable? Because you referred to quite a few different things there, such as patents and designs and trademarks. I'm sure there's lots more. So how do you map what's protectable and what the right mix is?
Yes. Okay. Well, when a company is scaling quickly, one of the most valuable exercises it can do is to take a step back and map its innovation and assets against the different forms of IP protection. So we mentioned patents, registered designs and trademarks, and even unregistered IP like copyright, trade secrets, and know-how. The goal isn't to protect everything. The goal is really to protect the things that genuinely matter to commercial success. The first step is simply to break the company's innovation down into categories, typically technology, brand, design, content, and know-how. And once you've separated the different types of value the company creates, it becomes much clearer which IP rights might apply. So, for example, technology will typically map to patents, aesthetic product appearance maps to registered designs, names, logos, and brand identity, those map to trademarks. And then we have things like marketing content and documentation that will fall under copyright, and things like recipes, processes, algorithms, data sets, and just general know-how. These might all be regarded as trade secrets. So even before you make protection decisions, this mapping exercise helps everyone see where the company's true differentiators are to be found. And that leads to the second step, identifying what is core to the business model. Growth companies can often have lots of interesting technology, for example, but only a subset of this might strategically be critical. So you want to ask what drives revenue, what would be most damaging if a competitor copied it, what would an investor or buyer of the company pay for a premium for. And when you understand this commercial criticality, you'll have a short list of assets that genuinely justify protection. And the
Mm.
third step is choosing the right mix, and that flows from the core value we've just spoken about. But it's also about practicality. For example, if the company has a technical invention that competitors could reverse engineer, then patents are usually the right choice. Patents also support investor confidence and give the company. If the value lies in visual appeal, so the look and feel of a product, then a design registration may be a faster and more effective option than patents. And for anything brand related, trademarks are essential, especially during rapid growth, because you want to stop others from piggybacking on your reputation. And then the last step is bringing it all together in a simple, actionable plan. For each of those categories, you decide what to register, what to maintain as a trade secret, and what to document and protect through copyright and contracts. And importantly, also what not to protect, because a good IP strategy is also about avoiding unnecessary cost. So yes, I would say this type of balanced approach, mapping and prioritizing different IP rights, will help you achieve the right mix and provide a clear story for investors about how IP supports the company's long-term value.
Thank you. Thanks, Adrian. I mean, coming to you, David, perhaps maybe it's a good time for you to sort of outline some of those core incentives that are available to innovative companies and where sort of protected IP can strengthen their position.
Yeah, good afternoon, everyone. So most of the government support of the incentives that are available focus on the technology category that Adrian mentioned before. Design, trademarks, etc., are probably less incentivized by the government or encouraged by the government through incentives. I'll come on to what those technology-oriented incentives are, but it's worth, as if companies are thinking about their overall incentive strategy and the level of government support that's available to them, think about some of the other areas that aren't necessarily linked to your IP. So say make sure your capital allowances, whether free ports is a factor for you, whether export or debt finance that the government provides. All of these things are things that the companies should be thinking about when they're looking at what government support is available. But focusing specifically on technology and innovation for technology, we see government support across that innovation life cycle. So there'll be support right at the start of your innovation life cycle, typically in the form of directed grants. So whether issued by the UK government or obviously now that we're returned into the the EU framework, there are Horizon grants available as well. But these are focused on maybe particular sectors or technologies. There are some sort of general grants that are available for companies, but they tend to be swamped now in terms of lots of companies making applications for let's say smart grants in the UK, and the government haven't been able to really handle and process that many. So many of those sort of general grants have fallen away from effective use, and it's now much more targeted government support, whether in maybe in environmental sectors or in particular geographies as well. So at the start of your R&D process, grants are a key thing to consider. And in applying for the grants, I've alluded to the fact that it's very competitive. It may be worth look. Your IP strategy can support that grant application. Companies that have recognised their IP and got a strategy for commercialising it, etc., that tends to encourage the grant awarding bodies to recognise that you're a serious sort of applicant for the grant. So at the start of your R&D, of your innovation lifecycle, grants are probably the most important ones, and they're ones because you often have to apply for them in advance of the detailed project. Then as you move through that innovation lifecycle, you may start to talk about developing new products, capabilities, etc. Then R&D credits start to come into view, and R&D credits are focused on on the actual performing and the development of that IP and supporting those. I won't go into too much detail on those today, but the scheme has changed a little recently. It's now what's called a merged R&D expenditure credit scheme. Still provides a 20% above the line benefit, 15% net of cash, but R&D is the key government incentive as you develop your IP. Then, as you move on to start to commercialize your IP, the government also provides patent box. So patent box, rather than a sort of a refundable credit, a cash that the government provides for you through the R&D scheme or direct through a grant, the patent box is there for tax-paying companies, companies who are profitable, and it allows them to apply a lower rate of tax to the profits that arise from the IP. That low rate of tax is 10% compared to the general 25%. So it's quite for companies who are heavily IP oriented and are tax paying, it can be quite a generous benefit. But the key across all of those is that IP needs to align with all of those sorts of things. As I say, as Adrian has alluded to at the start of your development, having an IP strategy in place will support your grant applications and make you a more serious applicant, a more weighty applicant compared to just some of the general applications that go through. Then, as you go into your R&D process, as you're starting to create your IP, then aligning that with your patenting strategy. Adrian hasn't necessarily talked about some of the conditions to get into say patenting your technology, but there are some dependencies between those that it's worth thinking about. And then the commercialization of the IP and then the patent box, that's after your patent has been awarded, or when you've applied for the patent, you can go back to the date it was applied for, and that's how the government are sort of incentivizing that element through that lower taxable profits that you'll see with there. So across the innovation life cycle and focusing on that technical category, the government provides different tools at different phases of your innovation.
Thanks, David. Adrian, I mean, thinking about it, what are the most common sort of IP blind spots that you see in companies that are scaling, and how can these issues sort of raise their ugly heads in events such as sort of fundraising or due diligence, or when somebody's going through an exit?
Yeah, sure. So unclear ownership is undoubtedly one common blind spot. Fast-growing companies often scale their technical teams very quickly, perhaps using freelancers, or they partner with universities and development houses. If assignments aren't put in place at the right time, or if agreements are missing the right wording, then the company may end up not actually owning the IP it thought it did. This usually surfaces in due diligence when investors or potential buyers are asking for a clean chain of title. They'll often want evidence that every contributor formally assigned their rights, and that obligations around confidential information and background IP are properly tied down. So if anything is missing, the company can end up chasing signatures under time pressure. And that is never ideal when trying to finalise agreements, of course. Another blind spot, missing filings or unprotected core value. Scaling companies are often innovating quickly, but the IP processes don't always keep pace with that. And this can mean that key inventions brands are disclosed before patents are filed, or patents are filed too narrowly, or protection is fragmented across markets. And in due diligence, investors look for alignment between commercial prospects for a technology and the IP strategy. And they want to see not just a list of filings, but evidence that the portfolio actually protects the company's differentiators. If they find gaps, for example, missing coverage in the US or Europe, or no filings around the company's most commercially important developments, then that can weaken the growth story and push down company
Mm.
valuation.
Mm.
Freedom to operate can be an issue as well. Companies often assume that because they have patents, they're automatically free to operate. Unfortunately, that's not how things work in the IP world. Freedom to operate is about understanding other people's rights. Scaling companies often don't carry out appropriate checks early enough, which means potential patent blockers or commercial constraints may only come to light when an investor begins asking about freedom to operate. And another blind spot is not seeing IP as a commercial asset. Some companies think of IP as a legal formality rather than something that
Mm.
actually enables partnerships and licensing or revenue diversification. And again, during due diligence, investors might look at whether IP supports the business model. Can it be licensed? Does it create barriers to entry? Does it give strategic leverage in negotiations? So if the IP hasn't been considered in this way, it can signal that the company hasn't fully aligned its innovation, commercial, and growth strategies.
Mm.
So these are the patterns we tend to see: ownership gaps, incomplete protection, limited FTO awareness, and just not leveraging IP strategically. The good news is that all of those issues are easily dealt with, but action should be taken early and certainly before a company presents to investors.
Mm. Yeah, I mean, David, where do you see the biggest missed opportunities when companies aren't sort of aligning their early IP strategy with their innovation incentives, sort of following on from that?
Well, really, whatever the motivation for the IP, for protecting your IP, whether that's sort of to set the technical motor, as it were, around your IP, or to be more attractive for investors, company valuation purposes, the the missed opportunities really fall into two categories. One is the missed benefits. You've not secured the incentives that are available to you, and the second is it's probably inefficient processes. It's probably a bit of a hidden missed opportunity in the sense of supporting the IP strategy, and then you've doubled up the effort maybe on your R&D applications or your patent box applications and so on and so forth. So there are two types of missed opportunity. In terms of the missed benefits, I think Adrian has alluded to some of those. Some of those relate to not identifying your IP and not protecting your IP at the right point. I mentioned at the start that there are sometimes some dependencies between government interactions and applying safer patents if you're looking to protect your technology in that way. One of the criteria for a patent is that sort of it's not prior art. It's not publicly available. When you're applying for various different government incentives, generally when you're engaging with HMRC, that any information you share with them in terms of R&D claims, it would be confidential. But you need to be careful when you're working, say, with collaboratively with for grant applications, part of a consortium or whatever. What information you're sharing, you're not breaching that prior art aspects. So the missed benefits, make sure you've got strong NDAs in place or whatever the case may be. One of the other, through not aligning, some of the other missed opportunities are some of the people opportunities. The people who are, say, developing the IP aren't necessarily people who are commercializing or protecting the IP. So sometimes benefits get missed because people aren't aware of what the benefits are. And so having a strong training on what is patentable technology, for example, or what is R&D for tax purposes, those are important ways in which you can sort of preempt some of these missing of these benefits. I talked before about the role of the life cycle, and it's recognizing that wherever you are in that life cycle, to think about the incentive strategy, for want of a better phrase, and your IP strategy as collectively rather than as very independent mechanisms, because otherwise you will get things that are missed between you. That also helps address that second missed opportunity in the sense of the inefficiency in terms of managing your IP and then preparing and securing your incentive, your innovation incentives. So the people who are often involved in developing that IP aren't necessarily the ones that you would that are day to day linked in with that IP strategy. So getting the team to be more interactive and integrated, the level of sharing of information, so that as new IP is developed, it's considered against the strategy and then protected as necessary. As Adrian says, there'll be some times where you don't want to protect IP. It's not worth protecting. But having better integration and better communication between your teams means not so much that you'll reduce your missed benefits, but it will also mean that it's more efficient in terms of how you prepare, say, your patent applications, or how you prepare your R&D submissions. So there tends to be two types of area that will see those sorts of missed opportunities. At a more practical level, there'll be you'll obviously, when you apply for patents, you've got various documentation that's required. There may be synergies and efficiencies that you can get from referencing that patent documentation in, say, for example, your R&D claim. Okay.
Thanks, David. And Adrian, how early is early enough to formalise an IP strategy, and what's kind of like a minimal viable approach that you would recommend?
What the right time to start formalizing an IP strategy is often much earlier than most companies expect. You don't need a full-blown portfolio on day one, but you do need the foundations in place as soon as the business starts creating something that is genuinely new, valuable, or differentiating. In practical terms, that usually means at the point where R&D begins taking shape, or certainly when the business starts speaking to customers, investors, or collaborators about their technology. But early doesn't have to mean complicated. A minimal viable IP strategy, something that's lightweight but effective, probably comes down to four building blocks. The first, ownership and confidentiality basics. Every employee, contractor, or collaborator should have agreements that clearly assign IP to the company and deal properly with confidentiality. This is probably the single most important early step, because without ownership, none of the rest matters. Secondly, identifying what is actually protectable. You don't need a 50-page IP audit, but you do need to know what the company is creating that is novel, technically meaningful, or of commercial importance. This could simply involve a short innovation capture process or a triage meeting between teams to decide what is worth protecting and what is better kept as a trade secret. Third, timely, proportionate protection. For many early stage or scaling companies, minimal viable protection might mean filing just one or two strategic patent applications covering the core invention, registering key trademarks and ensuring that any distinctive designs are captured before launch. The goal isn't to file widely necessarily, it's to make sure you don't lose rights through early disclosure, and that you protect the innovations that truly underpin the company's competitive advantage. And fourth, a simple forward plan. This doesn't need to be elaborate. Again, a one-page IP plan that aligns the product roadmap and commercial priorities is often enough. It should set out what the company will protect, what it will monitor, and how IP decisions will be made. So I think just to summarize all of that, I would say early enough is as soon as innovation starts happening, and a minimal viable strategy is one that establishes clear ownership, captures key innovations, protects what matters, and guides decisions as the business grows.
Thanks, Adrian. That's really, really clear, really helpful. And David, what about sort of aligning R&D documentation? When should companies be thinking about aligning that with their IP priorities?
Um, Thinking what Adrian has just said there, I'm sort of reminded of the older Northern Ireland political adage of vote early and vote often. It's likewise with IP and incentives. Start early and review it often. The earlier in the cycle, obviously, the better, especially if you're, say, if you're applying for grant applications and the like, which you'll tend to do very early in the cycle, making sure that that's aligned with your IP strategy. As I said, there'll be things that's in your IP that may strengthen your grant application. So consider very early in the cycle when how to align your IP strategy with your incentive strategy. And then we recommend sort of then as you progress through the life cycle on that, you adopt either, maybe sometimes it'll be an event driven sort of, or a milestone based approach, sort of as you go through various different stages in your innovation cycle, then have a quick sense check as to what's happening on an IP front, what's happening with the R&D front, or the pattern box later on, and make sure that you've got that periodic, maybe quarterly type assessment of what's happening here. Have I created new IP that I hadn't anticipated? Had I performed more R&D than I'd anticipated? So aligning regularly and often is important. Some of the outputs from those sorts of processes, maybe you'll be generating what I call, contemporaneous notes in R&D pilots. They will help you prepare for claims later on. So aligning on an early and then a regular basis after that can build up some of the supporting evidence you need for your incentive claims later on, particularly for R&D claims. But even as you move then into the commercialization phase and you're claiming patent box, showing the link between the economic substance of the R&D in the UK through to the patent box benefits, it will become an important aspect of there. And so maintaining contemporaneous notes, the logs, whether it's the harvesting sessions where you may sort of look at your general environment and I try and identify the IP that's arising, looking at your technical evidence logs, the disclosures that you're making for patents, etc. All of these things, these documents, if you have that sort of embedded in your processes, around your projects, that will help you track and trace the R&D costs and map them to the IP costs, but also that they will, going back to the earlier point about the missed opportunities, doing it on that structure basis can make it much more efficient for you going forward.
Mm-hmm. Thank you. What tends to cause a claim to fail? What are the things to watch out for?
Well, obviously with an R&D claim, for example, you have to persuade HMRC that you've got that you're performing R&D, and there are lots of reasons why HMRC may not consider it to be R&D. But obviously, if you've got, say, if your R&D is related to patentable technology, then that would tend to be a good, supporting evidence for it. But there are lots of reasons why R&D may not be successful. Sometimes it is about that lack of good contemporaneous documentation that evidences the nature of the R&D being performed. When you will come on to later on in terms of what the evidence looks like for patent applications, but that tends to be much more detailed than is necessary for R&D. But there is a slightly different emphasis that HMRC will be looking for in terms of supporting the nature of the R&D. And if you haven't addressed those concerns, you can't just sort of waive a patent and think you're going to be regarded as performing R&D. You need to address some of the documentation needs to address HMRC's concerns about what is R&D for tax purposes.
Yeah. Just a reminder for people watching, I haven't had any questions from the audience yet, but do remember that can feel free to put some questions into the Q&A function. We'll either pick them up during this webinar, or if we don't get time to do that, because I'm conscious we are wandering near to our end time, and we'll pick them up afterwards. Maybe Adrian, just coming to you, you talked about trade secrets and patenting earlier. What sort of indicators are there that suggest one should sort of pivot from secrecy to patenting?
Yes, so firstly, consider whether the innovation is realistically detectable by a competitor. So if someone could work out how your technology operates by using the product or analyzing it or reverse engineering it, then secrecy is rarely sustainable. And that's a strong sign you should look at patenting. A patent gives you enforceable protection even when the innovation is visible to the outside world. On the other hand, if the value sits deep inside a process that no one outside the company can realistically access, for example, a manufacturing parameter, an algorithm, weighting, or a formulation step, perhaps, that's where secrecy can be the stronger option. You can also consider the expected lifespan of the competitive advantage. Patents are great for innovations with long commercial horizons, where 20 years of protection aligns with the product life cycle. But some technologies move fast, especially with software, AI, and digital platforms. And if the innovation will be superseded or reinvented quickly every 6 to 12 months, let's say, patenting may just be too slow or too rigid. And in those cases, secrecy can provide more value. Conversely, if the innovation underpins your product for the long term, then the argument shifts very much back towards patenting. Also, if you're working with third parties, so customers, suppliers, universities, secrecy becomes much harder to maintain. Every new relationship is another point of potential leakage, when a technology will inevitably be exposed during trials, demonstrations, or integration work. That typically triggers the need to patent. But again, if development and deployment are entirely internal and the team can genuinely limit access, then secrecy remains viable. And if a company foresees licensing, joint ventures, or being acquired, patents create a clean, transferable asset, as I mentioned, that is much easier to value. And if the strategy relies on keeping a unique recipe in-house and monetizing it through internal production, secrecy can be perfectly aligned with that, provided the right controls are in place. So I think in summary, if others can discover your technology, if it has long-term commercial value, or if you will be collaborating externally, that's usually a cue to patent. If it's not discoverable, has a short life cycle, or is tightly held within the business, secrecy can be the better strategic option. But the key really is that the decision isn't fixed. It should be revisited periodically as the technology, the markets, and commercial strategy all evolve.
Thank you, Adrian. We've got 3 or 4 minutes left, and we've got 3 questions left. So I'm going to ask you to keep your answers short for the next 3 questions. So coming to you, David, you talked earlier about grants. How does having protected IP help us with that?
Well, for grant applications, obviously, IP is not, well, there are lots of different grant competitions and awards going around, and each of them have got their own conditions and requirements, but generally IP themselves isn't a requirement. But having IP and having an IP strategy to do that will lend credibility to your application. As I said, most grant competitions are very competitive at the moment, and therefore helping yourself appear more credible will give you a better chance of being successful in the grant application. That credibility comes from showing that you recognise what IP there is in this domain, but also you've got a plan for commercialising that IP. And often when the government is there to awarding grants or whatever, it is with the aim of helping companies startups to scale up, to grow, and whatever, and to develop. And so having a credible approach to the IP strengthens your application. It's also worth recognizing that, especially at the European level, grants are awarded to consortium, and so you'd be collaborating with a number of partners. Partners will find you a more attractive partner if you've got IP you can bring to the table, as it were, that will help with the project that's being funded. Those are the main things. I'm conscious
Yeah,
of time, but
yeah,
that's
yeah.
probably the key things.
Okay, coming to you, Adrian, on sort of documentation. What documentation do we need in place to sort of prove inventorship and assignment, especially when there's sort of other contractors and academia involved?
Yeah, so the inventorship is very much a question of fact around who actually contributed to devising the concept. The simplest way to demonstrate contribution is through R&D records. So this is something that David's mentioned. So logbooks, meeting minutes, and such similar documentation. Once the inventors are known, we can consider ownership and properly execute IP assignment agreements. And for employees, ownership typically is dealt with by way of employment contract. But vague wording about ownership should certainly be avoided. So just pay attention to ownership with regard to employees. Due diligence, investors will ask for the full chain of title. If any names are missing, you can be sure they will raise it with you. So important to get all that right. It's obviously important to correctly sign and date agreements. So just keep your eye on that. And ideally, all of these documents will be easily accessible. So just ensure that you keep your records up to date.
Thank you. We are about to go over, but I do want to ask this last question, David, because I think it will be useful for the audience. I mean, I guess it's just what are the practical steps that companies can be taking now to make sure they maximise their incentives over the next 12 to 24 months?
So the R&D regime has changed significantly recently. The introduction of the merge scheme, the demise of the old SME and the old RDEC scheme. So most companies are having to reassess how they prepare their R&D claims anyway. And increasingly, companies are recognizing that 10% tax rate rather than the 25% tax rate is an increasingly attractive proposition. So companies are already looking to reassess their approach to incentives, perhaps couple it with your IP strategy, review your IP portfolio, consider maybe a one-off IP harvesting session that Adrian referenced, where you look at your IP, see what's emerging, what new IP you may have got, or and whatever, and maybe set in place those strategic, those periodic reviews that I spoke about to look at your strategy. Also, picking up on one of the earlier points, think about whether your key business, technical, finance stakeholders understand what is IP. As Adrian introduced right at the start, there are lots of different forms of it. Making sure you understand how and when to protect it, how to integrate it into your own development, your own company processes, including R&D. And then final point from me, because I'm conscious of time, is one of the requirements of the patent box scheme is that you show a linkage. You're able to track and trace the R&D expenditure that has generated the IP that you're getting that lower tax on. So you start to put in place, even from when you're applying for your grant, that tracking and tracing of expenditure show that the economic substance in the UK is contributing towards the IP.
Thank you very much, David, and thank you much, Adrian. Lots to digest there for sure. Obviously, if anyone's got some further questions, please do get into contact with us or Adrian. Thank you all very much for joining us today. A quick reminder, please do fill out the feedback form that should pop up at the end of this webinar. Like I said, it's really useful. Other than that, thank you very much and enjoy the rest of your day. Thank you.